This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. We appreciate each of you agreeing to participate in this argument via Zoom. It is the safest method, I believe, for us to utilize at this point in time and continue to hear cases as we should be hearing cases. We will have the argument begin shortly, and I want to remind all of you, obviously you don't need reminding, but we will treat this argument as if we were in the courtroom together. So we'll follow the same protocol and procedure. I want to be sure and introduce your panel to you before we start. We have Judge Karma McGee from Savannah, Judge Christy Davis from Knoxville, and I'm Steve Stafford from Dyersburg. Ms. Tibner, anything we need to take up before we call the case?
No, Your Honor.
All right, you may call the case then.
Kacy Collums Davis versus Richard E. Davis, Jr.
And we will hear from the appellant.
May it please the court. I'm Laura Butler, and this is Elizabeth Fike, both from the Memphis Shelby County Bar. We represent the husband, appellant Richard Davis, in this appeal. With the court's permission, I would like to reserve 3 minutes for rebuttal.
All right.
All right. Your Honors, we are appealing the division of property, the classification of one piece of property we deem separate, the award of attorney fees and guardian fees, the award of alimony, and the designation of PRP. I don't believe that I will get to all of that today. We've briefed this thoroughly in both our principal and reply briefs. But the case has lasted 6 years and the record is very voluminous. I'm sure the court has seen. And I want to just touch upon something that I felt was probably the most confusing in the trial court's ruling and also from my argument's perspective. And that is the enormous amount of attorney fees that has been the attorney fee debt that has accrued in this case, and how it fits into the division of marital property and marital debt, which, according to the trial court's calculation, is 69% to the wife and 31% to the husband, which we believe is inequitable. First of all, wife takes the position in her brief that none of the attorney fees, including the attorney's lien from Suzanne Landers on the marital residence, should have been included in the trial court's calculation and division of debt and property. It is our position that wife has waived this argument because in her Rule 14C, which is located at volume 33, exhibit 52, page 9, she lists that attorney's lien as well as the other items as debts of the property, debts of the parties. The husband did that as well. But I do not believe that they can just say that this is not a marital debt at this point. Our position is the attorney's lien that is on the marital residence in the amount of $81,000 is a dissipation of the marital estate, and I will explain why. But I would like to just very quickly quote from a case that I cited in the brief. It's the Holdsworth case, where the court dealt with a large amount of attorney fees, and it says wife must also bear some responsibility for her choice of litigation strategy. Litigants are not flies on the wall observing the litigation in which they are embroiled. They maintain some measure of control over the lengths to which their attorneys reach, and they must bear some responsibility for it as well. While wife's counsel has clearly used every litigation arrow in his quiver in pursuit of wife's goals, and while she can certainly engage in such a strategy, she must recognize that she cannot expect the other side to pay for it. As I've explained in my brief, it is our position the wife took extraordinary efforts for 6 years to keep the children from their father, and the trial court even made this finding in her findings of fact, which is at volume 14, page 1960, that the wife has gone to great lengths to restrict husband's parenting time. I think in assessing whether the wife has dissipated the marital estate, it's important for the court to understand how much in attorney fees there are that wife has accrued. As we sit here today,
Ms. Butler, let me ask
yes.
you a quick It's not really related to the division of the assets, but the issue of whether or not the mother or the wife alienated the children. It seems like there's conflicting argument and citations to evidence in both of your briefs, and you've got some things in there that indicate that she did, and opposing counsel says that there was a specific finding that she did not alienate. So what does the record reflect on that?
Your Honor, I'm glad you asked. This takes me away from this argument for sure, but the
Sorry about
findings,
that.
it's okay. The findings, in fact, and conclusions of law is probably the best place that I would refer the court to, because the trial court made the findings that the wife alienated the children from their father. She says that the wife doesn't agree with the professionals retained in this case. She says that wife's efforts to limit husband's parenting time, because of that, he moved for guardian ad litem. The wife doesn't trust the opinions of the guardian or any of the psychologists. The minor children exhibit concern about spending time with husband only to satisfy what they perceive to be wife's wishes.
It's interesting to me that she makes all those findings, but then she also makes the wife the PRP.
That's part of our appeal, Your Honor. Dr. Sayoka issued a report in this case, and it is, I can find the exhibit for you here in just a minute, but his report, it's volume 32, exhibit 7, page 7. He recommended an equal parenting time and on alternating week basis with consideration given to naming husband as the PRP. So that's what Dr. Sayoka, who was the forensic custodial evaluation expert appointed by the court, said. And his whole report can be read at volume 32, exhibit 7. He also made a statement that the wife seeks psychotherapy to deal with her pattern of anger, distrust, and anxiety. If wife does not engage in such psychotherapy, Dr. Sayoka was fearful that the children would become alienated from their father or begin to refuse parenting time. He also said the children are positive about husband unless they are with wife, in which case they are negative about father. The youngest child offers stilted, even scripted reluctance to visit with her father during the sessions where wife is present. Wife's view of husband is negative. Wife's skepticism of husband's ability to care for the children in a loving manner has translated into anxiety, which has impacted the children. Wife is unwilling to accept multiple observers' accounts that the children enjoy their time with their father. Wife's negative views of husband leave little room to expose positive messages to the children. So that's what Dr. Sayoka said. I've also quoted Dr. Collins, who is the children's court-appointed therapist since November of 2014. She was appointed by consent order, and her testimony went on for about a day. And if you need to hear some quotes from her, but she was very consistent with Dr. Sayoka in her opinion, and that is in our brief, both the principal and the reply brief. Any other questions?
No, you can get back to your division of assets issue if you'd like.
Okay. In my 4.5 minutes left, I do want to emphasize that the wife, as we sit here, has unpaid attorney fees that have resulted in a lien on the marital residence in the amount of $400,000. That doesn't include what she has paid. The record reflects that Mr. Davis, as of November 2018, incurred $175,000. Now, the record doesn't have anything about updated fees for Mr. Davis, but Ms. Davis incurred probably twice what Mr. Davis incurred. And I think it is important to understand, my position is that this is dissipation. And while it is difficult to categorize what was for, the children and what was for property division, alimony and things of that nature, if the court looks at the summer of 2018 in the record, which is when the mother sought to remove the guardian ad litem after she filed the parenting plan with Dr. Sayoka's recommendation in it. Immediately after that, the mother filed a petition to remove the guardian ad litem from this case. And it is astounding how many volumes that takes up in this record. Out of 40 volumes of this appellate record, that is 10. And the amount that the guardian had to charge that summer was $16,495. That was for a 3-day trial and the pleading she had to file. That's at volume 12, approximately page 1641. Mr. Davis's fees were $13,000. That's at volume 13. But what's most important is the mother's attorney fees were approximately $59,000 for that endeavor, which was unsuccessful. That's at volume 34, exhibit 59, pages 21 through 25. And so their efforts just for that summer dissipated the estate by $90,000. And even after Dr. Sayoka testified to his report that the father should have 50-50 parenting time at that point, they continued on. And we still had to have a trial that started in November of 2018 and lasted off and on until February of 2019. And so the guardian had to charge an additional $17,000, which is also at volume 14, pages 1929 through 1936. So we believe that the wife's efforts have dissipated the marital estate. We are asking that the court accept our division, which is at Appendix C of my principal brief, and call that $81,000 lien a dissipation of the marital estate that should be credited to the mother's part of the division of asset and not to father's. In addition, the court only ordered mother to pay the remainder of the guardian ad litem fees, which we believe is inequitable. The total fees were $116,000. Father, with bartering and payments, paid about $78,000 to the guardian. She had $37,000 due and owing at the end of this. So I think it's important to note the court's finding in her findings of fact number 37. It says, because of wife's efforts to limit husband's parenting time, husband moved to have the court appoint a guardian ad litem. So again, the court is finding that the husband is having to take these efforts in order to just see his children. One thing, I've got 30 seconds, alimony. I think it is very important to note that the trial court made a finding that the husband has a deficit in this case of $843 per month. She speculated that the husband could make more money or reduce his housing expense. Of course, the trial court did not have the benefit of even knowing that Mr. Black was going to place a $320,000 lien on the house the day after her ruling, which does impact his ability to sell. And my time is up at this point. I reserve 3 minutes to rebut.
We will hear from the appellee.
Thank you. Good afternoon. May it please the court. My name is Vicki Hardy Jones of the Shelby County Bar. I represent the mother, Kacy Davis, in this case. As Ms. Butler has stated, there is not sufficient opportunity with the limited time that we have before this panel to argue each and every issue that has been briefed and raised by the parties. Given the limited time that we do have, I intend to spend my time arguing those issues most important to Ms. Davis, answering any questions that the panel may have, and otherwise relying on the brief that we have submitted in this case. With that, Ms. Davis respectfully submits that this court should reverse the decision of the trial court for 2 reasons. One, the trial court erred in declining to adopt and enter mother's proposed permanent parenting plan and in awarding the parties equal parenting time. And 2, the trial court erred in declining to disqualify the guardian ad litem in this case. Now, following the trial, which, as Ms. Butler stated, lasted a number of days over the course of a few months, the trial court entered a permanent parenting plan that designated mother as the primary residential parent and awarded the parties equal parenting time of the remaining 2 minor children. This plan that was entered by the court was largely consistent with the plan that had been proposed by the guardian ad litem, with the exception of the fact that the trial court designated the mother rather than the father as the primary residential parent. Mother submits that the trial court should have entered her proposed permanent parenting plan. Now, in its analysis of the factors under TCA 36-6106, the trial court found that the mother had, quote, performed the majority of the parenting responsibilities related to the daily needs of the children, period, close quote. The trial court also determined that the strength, nature, and stability of the children's relationship with husband have been adversely affected by wife's attempts to alienate the children from husband. Based on the trial court's findings of fact and conclusions of law as a whole, it appears that her decision to grant the father equal parenting time was based largely on her belief and finding that the mother had taken steps to interfere with the father's relationship with the children, which the father repeatedly labels as alienation. Respectfully, this finding is not supported by the proof that was presented at trial. Now, Ms. Butler referenced a number of quotations from Dr. Sioka's report. As she stated, Dr. Sioka was the forensic court-appointed psychologist who conducted a custodial evaluation in this case. Now, in fact, at trial, Dr. Sioka testified that the mother had complied with every order of the court that had been entered, including every parenting plan. That on its face would suggest that the mother has not been guilty of denying father any parenting time to which he was entitled under the orders of the court. And as the court will see from the record, a number of different temporary parenting plans had been entered leading up to the trial, all of which the mother followed. Dr. Sioka also testified repeatedly and without equivocation that the mother was not guilty of alienation. Specifically, Mr. Black asked Dr. Sioka during trial, "You, I believe, have expressed the opinion that the mother has not been guilty of any alienating behavior." Answer, "Not that I could observe." He went on to address other reasons why the children may be reluctant to spend time with their father, because there is no doubt that the proof was that the children were largely concerned about spending time with their father. Now, as part of his cross-examination of Dr. Sioka, Mr. Black read to Dr. Sioka allegations that had been included in the mother's petition for order of protection. That petition there had been an evidentiary hearing conducted on that petition, and the trial court's predecessor, who was presiding over the case at the time, found that the allegations in mother's petition were true and had occurred. Those allegations included an allegation that father had tried to run mother off the road when the children were passengers in her car, that he had then gone home and destroyed property that mother and the children came home to find destroyed.
Ms. Jones, those allegations, if I'm not mistaken, that form the basis for the order of protection, that was about 5 years before the ultimate custody hearing. Is that correct?
That's correct.
And what facts, more adjacent to the time of the actual trial would support a finding that father's not entitled to equal co-parenting time?
Well, Your Honor, first of all, father was under an order to refrain from the consumption of alcohol at all times.
A drink in January of 2017 at the Super Bowl, right?
That's correct. That's correct. And while his counsel has taken great lengths to emphasize that it was only one drink, the fact is that it was one drink that he had been ordered not to take. And when Mr. Black questioned him about that and questioned him about whether he understood that he was violating the parenting plan by taking that drink, his response was, "I didn't even think about it. I didn't even think about it." Further, father's additional violations of the court orders and consistent violations of the court orders, I would suggest, deem him improper to have equal parenting time. Further, notwithstanding all of father's actions, mother had created a very stable environment for the children. In fact, Dr. Collins, the children's counselor, testified at some length about how the children appeared. And she began treating these children in October of 2014. I think that's important because that would be at a time where the children had seen the father on a fairly limited basis for approximately a year at that point. And what Dr. Collins testified to was the girls were bright and engaging, well-mannered, adorable little girls, that they were quite articulate and engaging, that they were delightful, well-adjusted, doing well in school, and that the focus of her counseling was to enhance the children's relationship with their father and to get a schedule. She also said that it doesn't make sense to bring children to a psychologist week after week if things are stable. And things were at times going well. Now, Mr. Davis would have the court believe that those occasions when things weren't going well were due to some undue influence by the mother on the children, notwithstanding that there was no evidence of any specific actions by mother that created the children's anxiety about spending time with him. In fact, as the court goes through the record, you will see that Dr. Collins testified things were going well, and then Hadley reported that her father had spanked her. Dr. Sayoka conceded that he knew about this spanking, and he said that medical records that were made contemporaneously with this supported the fact that Hadley claimed that she had been spanked by her father. Dad did not.
Here's where I get confused, and I guess I'm going to have to go back and, obviously read through the entire record, but on the one hand, I've got you saying that the spanking was confirmed. On the other hand, I've got Dad's attorney saying that was fully investigated and was determined to be unfounded. So I can't make heads or tails based on the argument of what actually happened there.
Yes, and I think some of the difficulty that I have in reading through the record is that the trial court made findings of fact that quite simply are not supported by the record. And so there are statements in the trial court's findings of fact that mother alienated the children, that mother did certain things. But if the court reads through the record and then reads the court's findings of fact and conclusions of law carefully, the court is going to see that there are a number of issues where the trial court found that things either happened or didn't happen that are totally contrary to the proof that was presented by the witnesses and the evidence that was presented. Because, Hadley reported that her father spanked her. Dr. Sayoka acknowledged that he was aware that this had occurred. Some of the adults believed Dad. Dad denied that he had spanked her. In fact, Dr. Collins testified that she brought Hadley in and had a meeting with father, and that she knew that it was difficult for the father to say anything comforting to Hadley because he didn't want to say anything that suggested that he acknowledged that he spanked her, since he continued to deny it. But things like that caused an issue. Hadley also reported other behavior by father that caused her concern. She said that things not so significant in the big scheme of this entire case, but things that disturbed her, like if I ask Dad for food or I want something, then he says you have to give me a kiss first. And it made her uncomfortable. They reported that Dad yelled at them. There was the report of the cousin touching inappropriately, which DCS deemed to be unfounded. The girls reported concerns about Dad's driving. The girls reported a concern that there were guns out in Dad's bedroom. And in fact, Dad admitted that to Dr. Collins, told Dr. Collins that the house was being renovated and he had moved the guns out of the gun safe. So there are a number of things like this that had transpired. Keeping in mind, and part of why I think that the allegations back to the original order of protection are important, notwithstanding how long ago they occurred, is that those are not events that the mother told the children about or that the children overheard. They were incidents that the children witnessed themselves. And while they were very young, those things certainly made an impression on them and created some of the anxiety that they have associated with spending time with their father.
Ms. Jones, wasn't there testimony by the mother at the time of trial that some of those allegations, as you call them, were incorrect as to what the children had witnessed?
Yes, there was. In fact, I believe that there was an allegation in the order of protection that the children had observed the father physically abuse the mother. The father denied that he had physically abused the mother, but admitted that during the course of an argument, the mother's nose had gotten broken. But the allegation in the order of protection indicated that the children had witnessed physical abuse, when in fact the children had not witnessed that. So that, as far as I recall the record, was the point that the children had not witnessed that was inaccurate in the petition. I believe that the mother's testimony was consistent on all of the other allegations raised in the petition, including the fact that the father had left the loaded gun on the porch and texted the party's son that it was there. So these things obviously caused the children great concern. And during his cross-examination of Dr. Sayoka, Mr. Black went through some of those things and said, now that is the very type of behavior that can cause a child to be reluctant to be with another parent, isn't it? Dr. Sayoka's answer was, of course. Dr. Sayoka also testified in response to the question, you have found that the mother is neither sick nor alienating the children, haven't you? Answer, I found that the mother is not sick and she is not intentionally engaging in behaviors that could alienate the children. Yes, sir. Now, in describing the mother's behavior, Dr. Sayoka also said, there was a discussion about supervised parenting time, should alienation in its full form be demonstrated, which was not demonstrated to my satisfaction at all. It's not even close. Now, in this case, what we have is a father who has engaged in egregious behavior, and from an early time, back in early 2014, when he sought the appointment of the psychological evaluator, he began making allegations that mother and the older children were alienating the children. Now, I think that the testimony of Nicole Hamlet, the child's school counselor, is very important because she described the relationship that she had with Hadley that was independent of the relationship between Hadley and either parent and independent of any relationship with either parent. She testified about an event that occurred in October 2018 when father showed up to have lunch with Hadley. Hadley wasn't expecting him, and she was very, very upset. Now, mother was not at school. Mother was not in a position to be exerting any sort of influence over Hadley at that time, and yet she was incredibly distraught by this. Now, for reasons that are not clear, the trial court found that father was more willing than mother to facilitate and encourage the children's relationship with the other parent. This also was not substantiated by the proof in any regard. In fact, the proof was that mother followed orders of the court and that it was father who did not. Dr. Sayoka said, mother followed all the orders, including the parenting plans. Dr. Collins said it was never that she was refusing to do what I suggested or to try and help her daughters. It was father, the proof shows, who repeatedly failed to abide by the orders of the court. Now, I can see that my time is ending. I would ask that this court reverse the decision of the trial court and conduct a de novo review and issue its own ruling rather than remanding this case. Thank you.
We'll hear the rebuttal of the appellee.
Okay. You were asking about cites to the record where about the spanking, and Dr. Collins testified, volume 23, pages 60 through 61, that neither she nor Dr. Sayoka concluded that husband was abusive as wife alleged. What Dr. Collins did testify to, however, was that she, the mother was sending messages about the father. While she can't say for sure that she was telling her various things, Dr. Collins knew that that was the tone and message that she was sending. And that is the reason that she recommended week on, week off parenting time, because the children were only going to be able to know father for what he really was by spending more time with him. And that is at volume 23, pages 93 through 95. So we have two experts here. We've got the treating therapist, and we've got the psychological, Dr. Sayoka, the evaluation expert. And as far as not following orders, if you will refer back to my timeline in the brief, which starts at page 9, it's pretty clear what the pattern is. The mother stifled the father's parenting time. In 2016, the summer of 2016, the guardian ad litem with Dr. Collins recommended week on, week off parenting time in the summer. Then there were some new allegations. That's when the spanking incident came up. That's when Dr. Sayoka was appointed. A year later, Dr. Sayoka recommended week on, week off in the summer. And he recommended that in 2017 until he could get his report finished. The mother didn't follow either of those. And in fact, the order appointing Dr. Collins as the children's therapist in November of 2014 says that the parties shall listen to the recommendations of Dr. Collins. The mother did not do that. Dr. Collins wanted father to have more parenting time. She absolutely refused to do that. But what is strange is that even though the appellee makes these arguments that father is unfit and there was the drinking and abuse, they recommend, or they propose that he has 81 days with the children. I don't understand. If they think he's such a danger, why is he a danger to them for every other week, but he's not for the 81 days? And our position is because they know that they're not in danger, or not Miss Jones, but the mother. It is our position that Dr. Collins, Dr. Sayoka, everybody has proposed that the father have week on, week off. It is confirmed in the findings of fact and conclusions of law, the reasons why. And I think the court has to examine those findings and give them great weight because it judged the credibility of the witness. My time is up. We're requesting that the court reverse the alimony award, adopt our proposal on the marital balance sheet, and name father as a primary residential parent, as Dr. Sayoka stated in his report should be considered.
Thank you. We appreciate your argument. We will review the record and we will prepare an opinion as quickly as possible.
Thank you.
Thank you.
Mr. Hebner, if you will recess court until the call of the docket tomorrow, please.
This honorable court is now adjourned for today.
Thank you.